Yes, Mr.
My Lord, can I just deal with one almost discrete point? Before lunch there was some discussion about what happened if you were a foreign criminal sentenced to more than 4 years, in other words, outside the exceptions, and how you applied the concept in 117C6 in those circumstances to a need to demonstrate very compelling circumstances over and above those in the exception. The passage I think I was thinking of when I said there was some scope for dealing with the position on the basis that on the basis that the exception would have been fulfilled if you had been an under 4-year offender. That's making sense. One of the passages is in a case called Akinyemi. The passage is MS 756. It's volume 3, tab 36.
Tab
36.
36, thank you.
It's MS 756. And in paragraph 14, Lord Justice Underhill is addressing a possible construction of 117C6 to the effect that what it required was, if you were someone who fell outside the exception because of the length of your sentence, was that you both meet one of the terms of one of the exceptions, or would have met them if you'd had a shorter sentence, but then have to go on to show something over and above. Paragraph 14, just above letter F, records me as submitting that this was an over-literal approach, and the thrust of the provisions of the whole was that the very compelling circumstances which a criminal must show must be more compelling than those covered by the specified exceptions. No doubt in the paradigm case falling within subsection 6, one or other of the exceptions would be satisfied, but that might not always be so, and a more flexible approach is preferable so as to avoid a mismatch between the approach adopted under the legislation and that required by Article 8. Pointed out the issue was not in any event of substantial importance. Section 117A only requires the decision maker to have regard to the considerations in sections B and C, so that even if the stricter construction of subsection 6 were adopted, the Home Secretary could not be compelled to act in breach of Article 8, contrary to section 33, if that's what the deportation would entail in any case. And then the court, in that case, accepted that degree of flexibility. The other passage is in N.A. Pakistan, if I can just find that.
Same volume.
Same volume. I'm very grateful. The passage is at MS 965. And it's paragraph 30. Court says, in the case of a serious offender who could point to circumstances in his own case which could be said to correspond to the circumstances described in exceptions 1 and 2, but where he could only just succeed in such an argument, it would not be possible to describe a situation involving very compelling circumstances over and above those described in exceptions 1 and 2. One might describe that as a bare case of the kind described in exceptions 1 and 2. On the other hand, if he could point to factors identified in the descriptions of exceptions 1 and 2 of an especially compelling kind in supporting an Article 8 claim, going well beyond what would be necessary to make out a bare case, they could in principle constitute very compelling circumstances over and above those described in exceptions 1 or 2, whether taken by themselves or in conjunction with other factors relevant to the application of Article 8. So, my Lord, that's the answer that I can give to my Lord Calmer's point about how the domestic courts might deal with a strong case falling within, in particular, exception 1, the integration exception, but of a sort where Strasbourg will be unlikely to see deportation as a proportionate response, would have to be articulated on the basis that the issues that arose under exception 1 were very clear indeed, sufficiently clear to be compelling. So if I can then leave that digression, go back to the main course of the argument, back to Hesham Ali. Volume 2, tab 24. And the passage I now want is at MS 356.
Sorry, could you repeat that?
MS 356.
Thank you.
And the passage in Lord Reed's judgment runs from 37 through 38. Malone for Mr. MacDonald took your lordships to paragraph 38. Starting at paragraph 37, I won't read it, your court will be very familiar with it, but Lord Reed points out, just below letter B, that in MF Nigeria, the Court of Appeal accepted the submission made on behalf of the Secretary of State that the reference to exceptional circumstances served the purpose of emphasising that in the balancing exercise, great weight should be given to the public interest in deporting foreign criminals who did not satisfy paragraphs 398 and 399, or 399A, and then it goes on to say that in those circumstances, it was only exceptionally that such people would win. And then the opening part of paragraph 38 is effectively setting out an approach which is the one we urge in relation to section 117. So the first half dozen lines or so of 38. The implication of the new rules is that paragraphs 399 and 399A identify particular categories of case in which the Secretary of State accepts that the public interest in deportation of the offender is outweighed under Article 8 by countervailing factors. Cases not covered by these rules, that is to say, foreign offenders who have received sentences of at least 4 years and so on, will be dealt with on the basis that great weight should generally be given to the public interest in the deportation of such offenders, but that it can be outweighed, applying a proportionality test, by very compelling circumstances. In other words, a very strong claim indeed. So the point, which is our point, is that the exceptions, in this case in the rules, are particular categories of case in which the Secretary of State accepts that the public interest in the deportation is outweighed under Article 8 by countervailing factors. To satisfy the exception, that's the end of that inquiry. And that's straightforwardly the law as established by Hesham Ali on the rules, carried over, we submit, into the thinking in the in section 117. And to the same effect, there's a familiar passage in MF Nigeria, volume 3, tab 44. At MS 934, paragraph 35, it's common ground that the first step that has to be undertaken under the new rules is to decide whether deportation would be contrary to an individual's Article 8 rights on the grounds that, one, the case falls within one of the paragraphs. The case falls within paragraphs 398B or C, and one or more of these conditions applies, then the new rules implicitly provide that deportation will be contrary to Article 8. So that's the phrase I want, implicitly provide that the deportation will be contrary to Article 8. In our submission, the drafting of section 117C is to exactly the same effect. We set out the public interest in 117C3, say that the public interest requires deportation unless one of the exceptions is satisfied. But the creation of the exceptions implicitly accepts that deportation would be contrary to Article 8 if you're in the exception. So if your lordships will go back to our printed case, bedrock submission, as it were, is at MS 2433.
Sorry, give them that again, please.
MS 2433. Where we printed case summarises what I hope I've just said at paragraph 13, and the very short paragraph 14 submission is the time and place for any freestanding proportionality balancing exercise is when the court or tribunal concludes that sections 117C 4 to 5 are not met. I think three more stopping off places in my submissions. The first of them is the judgment of Lord Justice Elias in MA Pakistan. And I know this is Mr. Nafla's case, and indeed it discusses Mr. Nafla's submissions, but I don't think I can avoid going to it at all. It's part of the analysis. He will no doubt say what he wants to say himself. But if your lordships will find the judgment at bundle 3 of the authorities bundle, tab 43, starting at MS 886. Can I just draw attention, first of all, to paragraph 17, where he says subsection 6 falls into a different category again. It does not simply identify factors which bear on the public interest question. It resolves that question in the context of Article 8 applications which satisfy the conditions in paragraphs A and B. Let's say by stipulating that one of those conditions are satisfied, the public interest will not require the applicant's removal, since the interference with the right to private or family life under Article 8.1 can only be justified where there is a sufficiently strong countervailing public interest falling within Article 8.2. If the public interest does not require removal, there is no other basis on which removal could be justified. It follows in my judgment that there can be no doubt that section 117B6 must be read as a self-contained provision in the sense that Parliament has stipulated that where the conditions specified in the subsections are satisfied, the public interest will not justify removal. It's not legitimate to have regard to public interest considerations unless that is permitted, either expressly or implicitly, by the subsection itself. And we adopt that perspective. then I think I can go to the discussion per MS 901.
Well, I'm working from Mr. Nafler's core bundle, so could you give me the paragraph number?
36.
Thank you.
And the first sentence of paragraph 36 is looking at section 117B6, free from authority. I would favour the argument of the applicants. The focus on paragraph B is solely on the child. See no justification for reading the concept of reasonableness so as to include a justification of the conduct and immigration history of the parents as part of an overall analysis of the public interest. I do not deny that this may result in some cases in undeserving applicants being allowed to remain, but that is not, in my view, a reason for distorting the language of the section. Moreover, in an appropriate case, the Secretary of State could render someone liable to deportation and thereby render him ineligible to rely on this provision by certifying that his or her presence would not be conducive to the public good. That's the bright line point that we were exploring this morning, that the way the scheme is designed to work is to provide the bright line, and there may be some people within the bright line who wouldn't win on a freestanding Strasbourg case without the section, but that is what the language provides. And then he goes on to consider Ms. Giovanetti's analysis, says they face a number of difficulties, which I will leave Mr. Nafler to deal with, but they come down to the proposition that what is happening in the Secretary of State's case, in the present case, is an elaborate submission that although the legislature has deliberately chosen to provide for a test of reasonableness in 117B6 and a test of unduly harsh in 117C5 would appear to mean different things, when you come down to the Secretary of State's submission, they all come back to a need to recognise the public interest and weigh that against the countervailing position. And that is simply to ignore the nature of the drafting exercise. And as Lord Justice Elias says in paragraph 43, it says, the language of unduly harsh used in the subsection is not the test applied in Article 8 cases, and so the argument that the term is used as a shorthand for the usual proportionality exercise cannot run. I would have focused on the position of the child alone, as the upper tribunal did in the MAB USA case. And then he says, 45, he says, the approach I favour is inconsistent with Uganda. He says, oh, it's recent and we shouldn't depart from it. Over the page, just above letter B, says the critical point is that section 117C5 is in substance a freestanding provision in the same way as section 117B6. And even so, the court in Uganda, in the Uganda case, held that the wider public interest considerations must be taken into account when applying the unduly harsh criterion. It seems to me that it must be equally so in respect to the reasonableness criterion 117B6. And accordingly adopts that approach. Now, I mean, obviously at the core of our case is a submission that Lord Justice Elias was correct in that passage, and that the law took a wrong turning in KO, effectively, but in judgment of Lord Justice Laws at same bundle of the authorities, tab 45, the case starts at MS 938. the nub of the judgment is at paragraphs 20 to 26. MS 946.
Mr. Drabble, you may not be able to help on this, but we've got a transcript that is numbered 2016 EWCA Civ 617. In fact, it appears that there was a transcript of this judgment under number 450, but it's no longer available on the Court of Appeal website. Now, in this case is not directly concerning you,
No.
so perhaps you can't
I
cast
can't
any
help,
light.
except I noticed that
Well,
fact last night.
It would be helpful if, at some stage before the hearing ends, we could be told what's gone on. It seems unusual.
Yes. Well, I can't help. I did pick up the fact that there were two transcripts.
Yes.
In the course of preparing for the case, but I can't help beyond that. I'm
Very well.
afraid. Yeah. But going back then to the judgment, Lord Justice Laws turns in paragraph 22 to the interpretation of the phrase unduly harsh. Plainly, it means the same in section 117C5 as in Rule 399. Unduly harsh is an ordinary English expression, as so often its meaning is coloured by context. Authority hardly needed for such a proposition, but in any event, via Rail Canada would supply it. And then he goes through an analysis which starts with the proposition that the context in these cases invites emphasis on two factors. One, the public interest in the removal of foreign criminals, and two, the need for proportionate assessment. And then, crucially, he says, in my judgment with respect, the approach of the upper tribunal and MAB ignores this combination of factors. The first of them, the public interest in the removal of foreign criminals, is expressly vouched by the Parliament in section 117C1, and then 117C2, and he repeats it. It says in 117, it says in paragraph 24, steers the courts and tribunals and the courts towards proportional assessment of the criminal's deportation in any given case.
I think this was an extempore judgment, wasn't it?
It was indeed extempore, yes. And yes, your Lordship proceeds that in paragraph 26, the conclusion at the end of the day is that in my judgment MAB was wrongly decided. That's the upper tribunal case. I'm coming back to that. That's my next stop. We say far from being wrongly decided, it was very careful and correctly decided. It can be careful and wrong, obviously, but it was careful and correct. And we just respectfully submit that this analysis of Lord Justice Laws misses the two-stage analysis that we get from Hessian Alley and MF Nigeria. Do I mean MF Nigeria? Yes, I do mean MF Nigeria. The stopping point under the old rules was if you met the requirement of the old rules, one of the exceptions. That was the end of the inquiry. And so there's, with respect to Lord Justice Laws, nothing surprising to find the same operation effectively mandated by the terms of 117B and 117C. It's the natural meaning of the language.
And he also misses the point, you would say, presumably, about the self-contained quality of the particular provision.
Exactly.
What Lord Justice Elias was at pains to point out.
Yes.
Which, of course, complements your other argument that there are stages to be passed through. And if you happen to hit the right button, so to speak,
yes,
at the first stage, well, you don't need to progress to the second.
Yes, so the self-contained nature, the stages, and the actual language, the fact that the test in B6 is designed to give you a test which you apply without revisiting the criminality. And so is the test in C5. You apply it without revisiting the criminality. Satisfy it, and the exception is made good. Parliament has decided that's the appropriate way forward, and is not to be regarded as shooting itself in the foot or whatever. It's simply that is the way it's chosen to deal with this policy matter, so as to produce consistency, amongst other things. So that's our basic submissions, other than the final stop, which is the upper tribunal case law, on the meaning and application of the concept of unduly harsh. And if your lordships will pick up volume 4, tab 67, starts, I think, at MS 1393. Oh, sorry. Mr. Divinity quite rightly says that I've actually taken you straight into the passage rather than the beginning. The first page of the report is 1372, 1372. The passage is 1393. And it's paragraph 42 of the decision or judgment of Mr. Justice McCloskey. And in paragraph 42 and the paragraphs that follow, he carries out the exercise of remaking the decision by considering the appeal within the framework of Article 8 of the Convention. It says we are mandated by Parliament to give effect to the new Part A of the 2002 Act. We do so in the following structured way. And then obviously it wouldn't be sensible for me to read it all out, but it is a careful analysis, I think consistent with my submissions today, of the way in which you work through the statute. 117A, 117B. And then we get to 117C. He says, we begin by acknowledging Parliament's unambiguous declaration that the deportation of foreign criminals is in the public interest, the more so according to the seriousness of the offence committed. In this respect, we consider the appellant's offending occupies a position of moderate gravity in the notional scale of criminality. We find that exception 1 does not apply, as the appellant has not been lawfully in the UK for most of his life. No evidence warranting a finding there will be very significant obstacles to his reintegration into his country of origin. As regards exception 2, we find, as did the first tier tribunal, that the appellant has a genuine and subsisting relationship with a British citizen who is hence a qualifying partner. We further find that the appellant has a genuine subsistent parental relationship with the two 7-year-old children concerned, whose the birth certificates demonstrate are British citizens, and hence each is a qualifying child. And then he goes on to consider the concept of unduly harshness, and this is an important passage. It says, 4 lines down, as regards the appellant's partner, we consider that the separation caused by deportation and the natural consequences thereof would undoubtedly be harsh, as it would abruptly sever emotional ties and support, terminate a genuine and serious relationship of some 4 years' vintage, and remove the only father figure from the family unit, and hence the life of the partner's 7-year-old son. However, we are obliged to recognise that these are normal and typical effects of deportation, in circumstances where the statutory criterion of unduly harsh requires something over and above the usual consequences. We are required to act on evidence and conclude there is nothing in the available evidence which would warrant a finding that this criterion was satisfied. So what he's done is recognise that deportation will, in the ordinary run of events, produce harsh consequences. The requirement of undue harshness requires something over and above the sort of ordinary consequence that flows from deportation. Holds, therefore, that the impact on the partner is not unduly harsh. And then looking at the position of the 2 children and applying the undue harshness criteria, does come to the conclusion at the end of that paragraph over the page on MS 1395, in regard to the evidence available and based on findings already made, we conclude that the effect of the appellant's deportation on both children would be unduly harsh. Accordingly, within the matrix of section 117C, exception 2 applies. Then he goes on to consider whether there were very compelling circumstances. We've seen this passage already. Comes to the conclusion set out at the end of paragraph 43 that there are very compelling circumstances.
I mean, apart from the colourful language used in subsection 5, why are those consequences over and above what would be the ordinary consequence of the deportation of a father of a child in a situation, a father of a qualifying child? Because this only applies to qualifying children. Why is it over and above? I mean, I fully sympathise with the description.
Yes. Well, I mean, what Mr. Justice Bukowski is saying is that there is no alternative applying this statutory language to looking at the sort of consequence that would just flow from deportation and seeing whether something out of the ordinary for an extraordinary situation is following from it. That is precisely what would happen in the case of a undue harshness test on relocation. It's not would you die or whatever if you relocated. Is it just imposing a burden, a hardship, is over and beyond what is inherent in the underlying situation?
I suppose if the relationship was either remote or sporadic or not particularly close, it might be said that it would not be unduly harsh for the children to be severed from the society of their father. On the other hand, where it has all the attributes that Mr. Justice McCluskey has described here, well, then it may well be that in the preponderance of cases there will be undue harshness, but that's simply the outworking of the provision.
Exactly. I mean, it's at that stage you go back to the concept that it is designed to be a bright line provision. It's not designed to mean that in every case where there is some impact there is enough, or it's not designed to mean that you're dealing with people subject to very lengthy prison sentences who've committed very, very serious offences. You're dealing with a cut-off point, which is at least an intelligible cut-off point for someone falling within the class that is within the exception. The bottom line point is that there's no scope in the language, whatever reservations one might have, I submit you shouldn't have, but might have about the actual way in which Mr. Justice Bukowski describes the concept of undue hardship. The one thing that's very, very difficult to do is get back into a position where you're looking at the nature of the criminality in order to construe the width of the concept of undue hardship. Why on earth would the legislature require an exercise of that sort rather than simply saying, well, removal will be proportionate? We could just have left the test to the decision maker, the underlying Article 8 test, rather than telling it to concentrate on the position of the child and see whether or not the consequence for the child is unduly harsh. That's what it's done.
I don't know if you're going to come on to this, Mr. Drabble, and if you are, I'll wait patiently.
Well, probably not.
You've made a submission that 117C5 is the functional equivalent of what was previously in Rule 399.
Yes.
And that in Rule 399, proportionality didn't come into the assessment. But if you like, the rule was itself based on an assessment of proportionality by the Secretary of State.
Yes.
I'm wondering if there's an analogous, a similar analysis in relation to 117B6. I mean, the language used there is actually, I think, almost word for word the same as one found in what used I've come across it in what used to be an exception to the minimum income requirement.
Yes.
But I don't know if it appears in other places, and if you're going to develop that.
I wasn't, because I'm not primarily concerned with B6, is my excuse for that.
I suppose, of course, that's true.
But I mean, I'm certainly willing to go as far as to say that that's part of the thinking, I think. Well, maybe not the analogy with the rules, but the thinking that both B6 and C5 create an objective endpoint which is not dependent on a further evaluation of the public interest test, follows from the language of those two provisions and is the subject matter of Lord Justice Elias's analysis in the passage we've just seen. I mean, that I do say. So he does it. I mean, he does it because he is dealing with the analogy with the B6 case in going on to talk about C5. Comes to the conclusion that the language of both of them is not the natural language you would use if you were going to have another public interest evaluation. And that's why he comes to the conclusion that he would have done, apart from the judgment of Lord Justice Law. So I do say that. I don't say more. I leave B6 to others.
Yep.
And so the only other place to go to is the judgment, the other judgment of the upper tribunal, Judge Grubb, at bundle 4, tab 65. So, bundle 4, tab 65, the passage starts at paragraph 50.
Can you give me a page number?
Yes, sorry, I mean, so.
It's 1357.
Yeah, it's the.
We've seen that he quotes Mr. Justice McCloskey extensively.
Yes, he does.
And so we simply want to see, with your help, what, if anything, the upper tribunal judge adds.
Yes, the major thing that he adds, we have already taken on board to some extent. It's the passage 71 to 73. Still haven't quite caught up with myself, which apologies. So, passage at 71 to 73 at page MS 1362. And in particular, paragraph 73, which is a reference to the...
That's Lord Calmer's point.
That's Lord Calmer's point, yes. And I just rely on the whole of paragraph 73 as making that point rather well, but it is Lord Calmer's point. I can only repeat that it seems highly unlikely that the legislature would have chosen a word which resonates so much to immigration practitioners if it didn't mean a very similar approach to be conducted here.
Yes, Lord Justice Laws didn't think much of that point.
And, well, I dare say. I don't think I can submit anything other than I submit it's a good point. It's, I mean, we come back to what my learned friend, Ms. Giovanetti's underlying submission is, that despite the use of one test in B6, another test in C5, and another test in C6, they all come down at the end of the day to a search for the underlying public interest and a balancing exercise. Well, it's a very, very peculiar piece of drafting, if that is what it was meant to do. And that's what Lord Justice Elias says. I don't think I can, I mean, one can work through Judge Grubb's whole passage under the heading of unduly harsh. Both he and Mr. Justice McCloskey treat 117 as what they describe as a matrix, which is quite a sensible way of looking at it. You see where you get to applying the various compartments, as it were, created by the statutory test. And our submission is that if you satisfy the test in the exception, then that's enough. Well, Lord, unless there's anything else on which I can help for now, so those are my submissions.
Thank you very much, Mr. Howells. No, I think you're going to come next, Mr. Gill, is that right?
My Lord, if that's convenient, yes.
Yes?
My Lords, firstly, can I say that I'm unlikely to be anything like the length of time
But we rather thought that you wouldn't be.
I've been allotted. So far as the respondent's case is concerned, I will not deal with that at this stage,
No.
but only deal with it in reply to the extent that it is adopted. So far as our case is concerned, in the case of Pereira, I will take that as read.
Yes?
And our case there is set out. I can pick up the KO core bundle. Our case is set out at MS 2846. At the outset, can I just explain, so far as I understand it anyway, what happened with the transcripts in Uganda? It's referred to in paragraph 7 at page 2848. During the course of the hearing in Pakistan, Ms. Giovanetti helpfully informed us in the court that there was a extemporary decision of Lord Justice Laws in Uganda, but the transcript wasn't available at that stage. And as it is stated in paragraph 7 on page 2848, the transcript later emerged. And it's set out in paragraph 7, my
Yes.
Lord.
Are they the same?
Paragraph 7.
My Lord?
Are they the same?
Well, my Lord, I cannot say. I did at one point have 450, the first transcript, but at some point it was then withdrawn, and I can only imagine that it possibly went back to the judge for slight corrections, as sometimes happens.
So we should take the later one as being the authoritative text.
That's right.
I mean, they always go back to the judge these days.
My Lord, yes, but perhaps I shouldn't make any comments on what sometimes happens. But in any event, the later one was then later appeared, which is why the number changed at some stage.
Yeah.
But we didn't make any submissions on it, presumably because Lord Justice Elias, understandably enough, thought he was bound by it.
Yes.
That's all I can say about that. I don't think anything in particular turns on it at all. So far as our submissions are concerned,
What are you looking for? Because isn't your client home anyway?
my Lord, if your Lordship means, is my client not home now under a different sub-rule of 276 ADE?
Isn't that what he wants?
Yes, but that's right. But let me just explain the position, since your Lordship takes me to the very end point of my submissions. I'll deal with
But it's good. I'd like to see where we're going. And as I understand it, if Ms. Giovanetti is right, this point is entirely academic from your client's point of view.
It's not entirely academic, no. Since your Lordship asks me to deal with it, I'll deal with it. The position is this. This child, this applicant, made his application when he was a child. He was entitled, we say, to succeed under 276 ADE 14 had the law been properly interpreted. That would at that point have had subsequent consequences for his parents. That is what should now happen, in that we say if it is to be remitted back to the upper tribunal for re-decision, it should be remitted back on the correct legal basis for them to say that he succeeded in his application made at the time it was made in 2013 under 276 ADE 14. What Ms. Giovanetti invites us to do is to say now in 2018, you, the applicant, make a fresh paid application, which we would have to pay for. That would then be assessed, and if it is not allowed, we would then have a right of appeal. And we say, why on earth should we bother going through any of that when if the law is as it should be, is interpreted as it should be, then this appeal would be allowed outright. Or at best, or at worst, remitted back to the upper tribunal on the correct interpretation of reasonableness for the upper tribunal to pretty well formally allow it. That's the point.
Well, we're simply talking about the cost of an application, are we? As compared to the cost of appearance in this court. And I want to understand whether there's anything of significance in this case. Because if the position is your client is entitled to stay here, and everyone accepts that, then I'm not sure what we're doing.
My Lord, there are knock-on consequences in due course in relation to assessing the position of the parents. If we're entitled to succeed, if this appeal should have been allowed on the correct lawful basis way back whenever it was dealt with in the upper tribunal, that's the position we're entitled to.
I see.
Not some years on to say, because of the passage of time, you're now entitled to succeed if you make another application, therefore it becomes academic. No, the point of law is not academic. In any event, the point of law as to the interpretation of 276 ADE 14 is of some importance to other cases. That is the position, my lords. So what I invite the court to do is to basically approve the core set of submissions which are set out in our printed case at, I won't go over them completely, but they're at 2850, I'm sorry, at 2852. And our position essentially is this. We say, if I can just start the submissions in this way, that the issue here concerns, in this case, what is the meaning to be ascribed to the words, it would be unreasonable to expect the child to leave the UK, for the purposes of paragraph 276 ADE 14, and, because the words are the same, section 117b6. The answer to this may well be impacted upon, and the Secretary of State says is impacted upon, by the construction of section 117c. We say that the answer to the question of the issue as I just posed it, what is the meaning to be given to the words, it would be unreasonable to expect the child to leave the UK, we say the answer to that is to be determined entirely, or almost entirely, by what is in the best interest of the child, by child-centric concerns. We say that is what drives the analysis, that is what drives the policy choices to create specific exceptions, bright lines, and so on. There is no room, we say, in either 276 ADE 14 or in section 117b6, which is what a tribunal would then have to consider, for any element of the public interest to come into play in the sense that Ms. Giovanetti asks for it to come into play. It is simply excluded by the opening words of both the rule and by the opening words of the subsection 117b6. I'll explain that in a moment. This is a very clear policy choice based upon a previous context, and the previous context, and I won't develop it at any length at all, was what was called a 7-year child policy, in relation to which what has now happened is, by virtue of these clear, bright-line policy choices, a very specific and clear position has been taken in relation to protecting 7-year children and British children, so that there needs to be no further detailed analysis in terms of a proportionality analysis in their cases. And all that one asks for is it reasonable to expect that child to leave? And we say that nothing in either 276 ADE or, for that matter, in Part 5A, in any way qualifies the duty to have regard to, and as a primary consideration, the best interest of the child. Nothing at all. I can explain that simply in this way. The obligations, firstly, in the authorities bundle, volume 1, you have, of course, section 55, which is at MS 12, but I don't take time over that because I know your lordships will all be very familiar with it. And then, importantly, this, it's not yet been referred to at tab 4, MS 25, section 71 of the 2014 Act. It says, for the avoidance of doubt, this part does not limit any duty imposed on the Secretary of State or any other person by section 55. So it's, moreover, not only that, Part 5A itself is subject to, by its starting point, to the Human Rights Act. The Human Rights Act brings in, of course, basic stuff, brings in Article 8, and what Part 5A is doing is simply giving some indication of matters to which particular regard should be paid, in particular certain matters, and certain exceptions are carved out in exactly the same way as they were carved out under the rules. Now, in relation to deportation cases, your lordships have heard submissions as to how section 117C works. In relation to non-deportation cases, where the Secretary of State is not faced with somebody who has committed some criminal conduct, or where the Secretary of State has chosen not to make a deportation order on some other basis conducive to the public good, as if someone is such an appalling immigration offender to a very great degree, it could be said that in an appropriate case, it might be possible for the Secretary of State to make a deportation order on that basis, that their presence is not conducive to the public good. The Secretary of State hasn't done any of that. We looked at that in the passage that was just referred to from MA Pakistan. Rabble cited out. Therefore, in non-deportation cases, what should be the approach that should be taken? Now, what the rules and the statute do is they seek to address this. They seek to address this by, in the case of a child applicant, saying that under paragraph 276 AD14, if it would be unreasonable to expect you, the child, to leave the United Kingdom, end of story, your application falls to be allowed. Section 117B6 similarly takes that approach, but that is going to have particular impact on a parent. that is therefore a difference. And the 276 ADE 14, one is dealing with a child applicant, not a parent applicant. But the test is the same in terms of its language. So our primary submission is, and this is the point that is made in paragraph 19, subparagraph 3, at page MS 2852 of our case. Our primary submission is this, at the bottom. So our primary position is that para 276 ADE 14 and section 117B6 of the 2002 Act should be construed in the same way as set out elsewhere in the case. it does not involve any proportionality assessment, freestanding exceptions, etc. And then at subparagraph 5, in the middle of 2853, we say, alternatively, even if section 117b6 and or 117c5 permit consideration of wider public interest considerations, 276 ADE 14 certainly does not. Now, I don't need to go for that alternative submission, because I say we can win on the submission as it is put at the top of that page, on 2853. So,
But your primary submission, as set out in 19.1, is to equate not reasonable to expect the applicant to leave the UK with best interests.
that's right, that's right.
You ask us to interpret the phrase, the clause, it would not be reasonable to expect him to leave the UK as meaning it would be in the best interests of him to stay in the UK.
That's right.
But it could have said that if it had meant that.
Well, I'll deal with that, my Lord.
Very well.
I know that's exactly what Lord Justice Elias said, but I'll deal with it.
Very well.
The position then is this. So far as the rule itself is concerned, can I just show you the rule so that we actually have it in mind? The rule is at Volume 1, tab 17, at page 2, MS 235. It says, the requirements to be met by an applicant for leave to remain on one of the grounds of private life in the UK are that at the date of application, the applicant, 1, does not fall for refusal under any of certain grounds. Now, when we go to those grounds, which are in tab 19 at 240, you can take it from me without going through them in detail, that they are concerned with criminality and conducive to the public good type situations or where false representations have been made. Matters of that sort. So this rule, on its face, takes into account the public interest to the extent that it needs to do so. It does it explicitly in 276 ADE 14, 276 ADE 1, and then little 1. And then the second point on MS 235 at the top is he's made a valid application, etc. And then 4 is under the age of 18 and has lived continuously in the UK for at least 7 years. And it would not be reasonable to expect the applicant to leave the UK. Now, there is no element there of being here unlawfully or being here precariously, no element of the public interest at all being referred to there.
Well, not expressly, but aren't we looking at this sub-rule on the assumption that, subject to his private life claim as the basis for staying here, he's otherwise likely to be required to leave on what one assumes are grounds related to the conduct of an immigration policy in the public interest? I mean, otherwise I don't understand how you can ascribe any meaning to, and it would not be reasonable to expect the applicant to leave. I mean, why should an applicant leave unless there's some underlying reason why, but for his claim, he would have to leave?
If your lordship is saying, well, precisely that he presumably is here in some capacity which requires him to leave.
Yes.
What we say is that this rule applies to anybody who is whether lawfully here or unlawfully here, none of that matters, provided only that they are here, that it would be unreasonable to expect them to leave, that is enough. It is not saying unreasonable to expect them to leave, balanced against public interest considerations, such as the fact that he is unlawfully here. It's not saying that at all. There's nothing in that language which imposes that balance. To the extent that there is concern about his quality of residence here, his conduct here, and matters of that sort, the opportunity was there to spell it out, and that opportunity has not been taken because in the opening words of 276 AD 1.1, it says, does not fall for refusal under any of the certain grounds. So it could have said that he will fall for refusal on a certain basis. It could have qualified it in other ways, even if something else needed to be said. Well, it doesn't say it. And then if one looks at how the rest of the language is structured, it says 5 is aged 18 or over and under 25 years and has spent at least half of his life continuously in the UK, discounting any period of imprisonment. So it is talking about periods where there is some concern about his quality of residence there. Then in 6, it is talking about other types of considerations, but there would be very significant obstacles to the applicant's integration in the country to which he would have to go if required to leave. So it spells out very precisely what needs to be looked at in terms of the criteria. Nowhere does it say that the quality of his presence here, simply by virtue of the fact that he's unlawfully here or here without leave, is a relevant consideration. It is drawing a bright line in the case of children. And that was the submission that the Court of Appeal accepted. They said, reading these provisions on their face, that's what they mean.
Can you help me with some example, if one wholly ignores the public policy in applying immigration control to someone who either has no right to be here because he's come here unlawfully or his period of lawful residence has ended, and therefore he's having to make an application of this kind. Can you think of anything other than the immigration control as a candidate for making it reasonable to expect him to leave? I'm just trying to put flesh on the bones of this phrase in a way that accords with your submission.
Lord, if you assess the applicant and you say, well, his best interests upon a holistic assessment of his circumstances really indicate to us that there are real concerns about the quality of his situation here as compared to somewhere else. For instance, he may be at risk from parents. Not all family life with parents is always in your interests. Or it may be that, in fact, in order to get away from a family life which is not in his best interests, it's in fact better that he go and live with an aunt in the USA, for instance. It would be in those sort of extreme situations where it may be thought that it would not be unreasonable to expect the child to leave the UK.
What if he led a somewhat rootless existence, didn't have any strong familial ties or didn't have any strong social connections? In those circumstances, might it be said that it would not be unreasonable to require him to leave?
No, that is not a situation which would entitle the Secretary of State to require him to leave.
Well, there are features or characteristics that are associated with the individual, are they not? Why would they not be relevant considerations?
Well, my Lord, there are two possible ways of looking at it. If it is going to be all driven, as I say it should be, by a best interest analysis, then what one does is to is to look at that person's situation through a best interest analysis. If you conclude as a result of that, because of his rootlessness and so on, that and remember we would be dealing with a child where there are state obligations, if it would be thought in those circumstances, actually, this situation is so rootless in this country that in fact it may be better that, in his best interests that he go and live somewhere else. And we've investigated that, made appropriate inquiries with the country overseas, then that may be that sort of situation, but it would be best interest driven.
That rather implies that the presumption must be that it is almost invariably in his best interest to remain here, unless it can be shown positively that his best interest would be better served elsewhere.
My Lord, it does, but I don't shy away from that. I say this rule is making that absolutely, this is a policy choice that is being taken in order to make it clear in that way. Alternatively, I said there are two possible ways of looking at it. Either it is all driven by best interest. The alternative is, and I'll come back to my Lord Wilson's point in a moment, the alternative is, well, there may be some slight difference between what is in the child's best interest and what is reasonable to expect the child to do. Difference may not be very great, but there's still logically some difference. Now, I'll still deal with that point. I say it's actually the first of the ways in which I put it, but whichever of the two alternatives is used, and I've put the other one in the alternative in those submissions that we were just looking at a moment ago, this appellant would succeed. So that, we say, is the proper analysis of 276 ADD. I'll develop these points in a moment, but my Lord Wilson asked me about the fact that the rule and indeed the statute could have said best interests, if it had meant best interests. My Lord, Lord Justice Elias basically said two things about this. He said, firstly, as my Lord has said, the Parliament could have used the concept of best interest instead of reasonableness if it wanted to, in 1176 and also the Secretary of State in the rules. And secondly, he says there's nothing intrinsically illogical in the notion that even if the child's best interests are to stay, it may still not be unreasonable to require the child to leave. Those are the 2 points he basically made. Maybe reverse sides of the same coin, but essentially those are the points. Now, as to the first of those, we say the possibility that Parliament could have used the words best interest doesn't tell us anything. It's a possibility, but it doesn't tell us anything. It begs the question of what is the difference between the two phrases that I'm putting before you. The question, in a sense, maybe this turns it on its head, only has meaning if the concept of reasonableness is assumed to include some element of the public interest. Only if the concept of reasonableness includes some element of the public interest does this question have any meaning. Should Parliament have used best interest or not? But this inquiry doesn't arise because all relevant elements of the public interest, both in the structure of 276 ADE and in 117B, have already been taken into account in the way the whole is structured. And we say that I've dealt with that in relation to 276 ADE to the extent that there were concerns. They are dealt with in 276 ADE 1, little 1. Now, and I'll deal with how this submission works in relation to the statute in a moment. So far as the second point is concerned, that there's nothing intrinsically illogical in the notion that even if the child's best interests are to stay, it may still be not unreasonable to require the child to leave in possibly some circumstances. we say, well, what other types of grounds are there? On what grounds could the question of reasonableness be decided against the child if the best interests require the child to stay, if the best interests require the child to stay?
Well, I don't think that's quite what Lord Justice Elias was saying. He didn't say that if the best interests of the child require that he stay, that it might still be reasonable. What he said was, if the best interests of the child are that he remain, not that they dictate the outcome,
Yes.
but they are that he remain, there can be conceivable circumstances in which it's not unreasonable to require him to leave.
But, my lord, if the best interests are that the child should remain, then we say, and your lordship is right, the rule doesn't use the word require either, then we say if that is what, if the best interests are that the child remain, there's really nothing left in relation to reasonableness to take into account. The extreme type of cases that are postulated and that we discussed a few minutes ago, while given the answer to those types of cases, so far as there is concern about an individual's conduct in some way, it's dealt with, as I've said on a number of occasions, in 276 AD 1. And so far as the points about rootless existence and matters of that sort are concerned, well, it's only insofar as there is some concern about a person's presence here that only if the Secretary can show certain concern about a child's presence here, can the Secretary of State really take any form of action. And that action is available to the Secretary of State to take in terms of a removal decision.
But Mr. Gill, family lawyers are well versed in weighing up rival options for children. And one can well imagine, in a case like this, a weighing up saying, well, there are 5 reasons why actually it would be in the best interests of this young man to remain in the UK. But when I look at Sri Lanka, there are actually 3 quite good arguments why it would be beneficial for him to go there. What shall I say about that? And the conclusion might well be, Mr. Gill, it is in his best interest to remain in the UK. But hand on heart, I cannot say that it is unreasonable to expect him to go to Sri Lanka. Now, that's nothing to do with public interest and all the rest of it. That's simply looking at it from his point of view. From my point of view to you, these two concepts are really distinct.
Well, my lord, if that's right, then it will be the other of the submissions.
It would be.
That would be in play, and I would submit should be accepted. But I say, in that event, that in the vast majority, if not all then, in the vast majority of cases, it will be the best interest which drives that analysis. It may not be that in every case it does so, but that would be my fallback position.
Hasn't it got to go back in any event? I mean, what I'm trying to understand, you won your appeal below, and it's going back. And one of the problems you had was you didn't call any evidence about what your best interests were. And as I understand it, the best you can hope for is for it to go back and for that to be considered properly. Not quite. I mean, you seem to be trying to say that we've got to say that your best interests inevitably require you to stay here, and that's the only answer we can give. But
Well,
that
my lord,
can't be right, can it?
in that event, a remittal would occur, and it would occur, but at least on a correct interpretation of the
But obviously, in all these cases, we've got to decide what we think the law is. But the best you can do is for the case to go back and be considered on the proper basis, and perhaps with some evidence about what your best interests are.
Well, I do accept that one of the points that Lord Justice Elias made is that the upper tribunal judge had not in fact carried out a proper best interest analysis.
Well, he wasn't given any material to do it.
Well, I'm not sure about that.
Well, that's what he said. I don't know whether that's right or not.
Well, there was, there are a number of submissions set out in our written case which impact on that, but certainly that inquiry wasn't properly carried out by the judge, which is why there was a remittal. But at least the remittal would then occur on the correct lawful basis as to what is meant by the test. So. Well, Lords, in relation to 276 ADE1, you have my submission on the structure. You have the approach that Lord Justice Elias took in relation to that. And we say this is 276 ADE14 came into existence in December 2012. In the form that it is in. The statute, Part 5A, came in July 2014, and we've seen how the statute works. And you've had that essentially in the submissions that have already been made. And in relation to that, what I say is this. The statute appears at tab 7 of the authorities bundle, and that is MS 83. You see that this is all essentially subject to the Human Rights Act, but gives some indications of how 117A2, how the public interest question should be approached. Court of Trial must in particular have regard to certain considerations. And then you have 117B. And the structure of it you have already seen, that 117B1, 2 and 3 are provisions of a certain sort. Then you have 4 and 5, which are provisions of a different sort. And then you have 6, which is essentially carving out a freestanding exception in the way that Mr. Drabble explained in relation to 117C5. In the same way, it's carving out an exception. Now, there is an analysis of this structure in a case called Trebowen, which I can invite you to look at, which is in volume 4 at tab 72, which is MS 1486. And we say the structure is explained by Mr. Justice McCluskey. Now this decision is in 2 parts. The first part was given before Uganda, Lord Justice Lawes' case was decided, and then there was a second part. And this is a combined decision where the first part is then incorporated in. He explains this in the preface at 1487. Your Lordships would just see how he explains it there.
Yes.
And having explained that, he then sets out on page 1488 the Part 1 decision given before Lord Justice Lawes' decision. He explains the issue in relation to the meaning of reasonableness at paragraph 11 on 1492. That's where his analysis starts. And it's a bit of time to read it, but I won't, and I'm not proposing to go through it all. I'll just give you the headline points. he poses the question at paragraph 14, is there any other element of the public interest other than that which is dictated by the word reasonableness from a child-centric point of view? He then sets out other tribunal case law which is consistent with his view and our view, case of dealer. And then he explains the structure. I would invite the court in due course to read paragraphs 16 through to paragraph 23 in some detail, because he explains why there is a certain element, why elements of the public interest are mentioned in 1, 2, and 3, sections 1, 2, and 3. He gives a view of the little weight provisions in 4 and 5 and describes them as really matters to do with choices by the applicant or immigrant in question, and then essentially concludes that so far as 117b6 is concerned in paragraph 19 on page 1497, so far as 117b6 is concerned, there is a separate and special dispensation for members of that class. In the middle of paragraph 19 on 1497, the most striking feature of this discrete public interest is its focus on one of the most vulnerable cohorts in society, namely children. The focus is placed on the needs and interests of these vulnerable people. So just as 117c5 talks about effects, what we're talking about here is it reasonable to expect the child, from the child's perspective, to leave? It's not building in anything else whatsoever, because the way 117b6 is structured is creating an exception. And he sets that out there, we say, very, very clearly. Now, his comments at the bottom of page 1496, that these provisions must be, so far as 4 and 5 are concerned, these provisions must be considered and given little weight. Now, they don't matter for my purposes, but there is further analysis of this, as you may have seen in the case of Rupiah, which I'm not going to go through, but if I can just give you a reference to it, it's at volume 3, tab 50 at 1046, but I understand your lordships are due to hear an appeal in that case in July of this year. I don't need to, that would be concerned, I suspect, with the meaning of precariousness. And so I don't need to deal with 4 and 5, but I say that in the way in which Mr. Justice Zaklasi was putting it at the bottom of 149, MS 1496, that they must be considered and given little weight, puts it perhaps a bit too highly even for 4 and 5 purposes, but those are not in fact an issue before this court. But one, of course, is conscious of what may be said with impact on other cases. So the crunch point in relation to this, at the end of paragraph 18 on 1497, he says, furthermore, section 117b6 is formulated in unqualified terms. In cases where its conditions are satisfied, the public interest does not require the removal from the UK of the person concerned. In this respect, also, it is different from its siblings, which contain no comparable instructions. He means 1, 2, and 3. So that essentially is the approach that I would invite you to take to this. So far as And we say nothing in any of the other case law undermines this submission, and moreover, it supports it. What we say about the meaning of reasonableness, we say is also supported by the case of ZH, which is volume 2, paragraph, volume 2, tab 34, at MS 735, paragraph 29, where Lady Hale describes almost entirely from a child-centric point of view what is meant by looking at the word reasonableness. Of course, she is then, in that context, saying later, of course, what is reasonable has to be then weighed against, in a standard Article 8 analysis, against a public interest in deporting somebody. But that's in a case where there is no 7-year child. That's in a standard, or a policy like this. That's in a standard Article 8 assessment case. But what I draw from paragraph 29 is what she says about the meaning of reasonableness. It's all child-centric factors. Moreover, our point that paragraphs 276ADE14 and section 117B6, and we would say 117C5, are all creating exceptions where there is no proportionality analysis involving wider public interest considerations, other than those relating to the child. We say that that is supported not only by Hesham Ali and MF Jamaica, references to which you've already been taken, so I don't take you to them, but also by, after Hesham Ali, a case, and after Uganda, a case in the Court of Appeal, VM Jamaica, which is at volume 4, tab 54, MS 1126, at paragraph 67, where Lord Justice Sales says there is no proportionality assessment in 117C5. Now, if that's so for that, it must similarly be the case in relation to 117B6, and it must be the case in relation to 276ADE14. And he was making those comments with the benefit of the decision in Hesham Ali, because he had seen what Lord Reed said in paragraph 38, which Mr. Drabble has already taken the court. And it's because Hesham Ali has explained the structure of the rules and how certain exceptions are carved out that we then get this position in VM Jamaica, so that there is, in fact, a direct authority in the Court of Appeal itself which directly contradicts Uganda.
I didn't think it was allowed to contradict
Well, he doesn't
the
say
binding
that.
decision. How come that he doesn't feel inhibited by Lord Justice Laws's decision?
Well, my lord, I think the reason would be that because one had in between the benefit of the judgment in Hesham Ali, and we get paragraph 38 in Hesham Ali explaining how the structure of the rules is creating certain exceptions. That is why I suspect Lord Justice Sales puts it in the way that he does.
Very well, thank you.
But in any event, it doesn't matter it may have been an argument to put in the Court of Appeal in a 117C5 case to say that there is conflicting authority, but at this level it doesn't matter.
Of course not, no.
The court's going to have to decide for itself. There are then, I think, just certain points to by which I need to, I think, explain the difference between reasonableness and unduly harsh. Because we say that reasonableness is driven by child-centric considerations, if not entirely by best interest considerations, at least by child-centric considerations. And if it is unreasonable to expect a child to leave by reference to those considerations, then the child must be allowed to stay, and so must the parent under section 117b6. Then one asks, well, what's the difference between that and the approach taken under 117c5, where we have a structure which is similar, but a different word, such as unduly harsh? Now, in relation to that, Mr. Drabble has already, we say that there's no difficulty with any of this, provided one keeps at the forefront of one's minds that one is always looking at child-centric considerations. So all that one is doing is asking whether the impact on the child for 117c5 purposes will be unduly harsh. The points have already been made, and I don't think I need to elaborate on those points. Yeah. But I say that it is not a standard which requires it is not a test which requires a proportionality analysis, nor is it something which can justify some gross interference with a child's best interests, because what one is doing is we're starting from a fairly low threshold under the heading of reasonableness. It would be unreasonable to expect a child to leave the UK. If that is all driven in 276 AD 1.4 and 117b6 from a child-centric point of view, then simply asking whether it's unduly harsh may be raising the threshold somewhat, but not excessively. And that is done deliberately in order to ensure that the children of foreign criminals, where the foreign criminal is a medium offender, do get a certain specific, clear, easily identifiable benefit and treatment. It's a bright line type test. True, it will involve assessment in an individual case. To how far above a best interest standard does one look at whether the impact on the child is unduly harsh? But it may not be very far. So the way in which Mr. Justice McCluskey explains it, that there are going to be incidents of deportation, for instance, which are always going to be there. Well, of course, they're always going to be there, but that doesn't help you answer the question whether the impact, the effect on a child is going to be unduly harsh. You still have to look at child-centric considerations. You can't ignore those effects. Those effects are going to be there, but that doesn't mean that they are necessarily to be ignored. They are actually to be taken into account and evaluated in the particular case. There may be differences of outcome in particular cases, but that is a matter for the judge to decide in a particular case. What cannot be done, whether in 276 ADE 1.4 or 117b6 or 117c5, is for this analysis to be infected by any other consideration of the public interest for the reasons that we explained to Lord Justice Elias and that he fully accepted. So that, I think, covers most of the core submissions. There are, however, a few additional points that I just want to make in relation to this. There has been reference to the case of MK. This is in Volume 4, Volume 4, tab 67, page MS 1372. And it starts at 1372, and the passages particularly paragraph 46 at 1397. Mr. Drabble has taken you to all that. What I just wanted to draw to your attention is that in MM, I do apologize, in MA Pakistan, at paragraph 59 on MS 908, the analysis...
Sorry, 90 what?
908,
Thank you.
paragraph 59, Mr. Justice McCluskey's analysis in MK, that judgment was described in approving terms by Lord Justice Elias as being thoughtful judgment, and he clearly is impressed with it. And we say that there has been a consistent approach at the tribunal, other than the case of KA, which then became MM Uganda and KO Nigeria and MM Uganda, which were then dealt with in the Court of Appeal. That's Mr. MacDonald's case. Other than that, the thinking at the tribunal level has been essentially that these provisions, 276 AD 14, 117B6, and 117C5, and create exceptions, and the latter two mirror what was in the rules in the way that has already been explained. There is a separate, so far as the policy is concerned, there was a 7-year child policy previously in existence. Now, I don't need to spend any great time on this, because I say that the submissions that we've set out in our written case are ample to explain this background. And these submissions are at MS 2858, paragraphs 38 to 46. All that one is doing here is to explain the context in which a policy choice was made, both in the rule 276 AD 14 and in the statutory scheme, to create this exception. Because prior to that, there had been this policy, which is then described in these paragraphs, and in the case of NF Ghana, which is at volume 3, tab 48, 1002, but the relevant passages are set out in our printed case at MS 2859. And we end up by saying it's in this context, paragraph 46 on 2861, that the policy choices were then subsequently made to introduce bright lines, to make the position even better and clearer for children of a certain sort. There having been a complete lifting at the end of 2008 of the immigration-related reservations to the UN Convention on the Rights of the Child. Hence the creation of these, we say, subsequently the move towards creating these bright lines. So that explains how this whole situation has developed. There is a point that I want to make in relation to a case called EV Philippines. Now, what Lord Justice Elias did was he referred to this case at the request of the other side, because it was in their submissions. And if we look at page 899, which is Justice Elias's judgment, he cites there at letter C a comment that is made by Lord Justice Elias in the case of EV Philippines. It's set out in the middle of that page, where he says, in my judgment, therefore, the assessment of the best interests of children must be made on the basis that the facts are as they are in the real world. If one parent has no rights to remain, but the other parent does, that is the background against which the assessment is conducted. If neither parent has the right to remain, then that is the background. Thus, the ultimate question will be, is it reasonable to expect the child to follow the parent with no right to remain to the country of origin? And we say that this sentence, much used by the Secretary of State, in fact, it does not properly reflect a best interests analysis. EV Philippines was not a 7-year child case. It was a normal Article 8 case. At paragraph 53, which is then at page 906, Lord Justice Elias, having set out the principles in Zumbas with which this court will be familiar, including the principle that a child must not be blamed for parents, must not be blamed for matters for which he or she is not responsible, such as the conduct of a parent. Paragraph 53, he says, paragraph 7 justifies the observations of Lord Justice Clark in the EV Philippines case, that the best interests of the child are to be determined by reference to the child alone, without reference to the immigration history or status of either parent. And if my primary submission were to be right, that the test of reasonableness has to be assessed by reference to best interests, also it would be the case that the immigration history or the status of parents are not relevant, but I can still make that point even if the concept of reasonableness is a slightly broader concept than just best interests. He then says at paragraph 40, he has dealt with it, paragraph 48 on 904 with the EV Philippines case. In that case, he quotes Lord Justice Christopher Clark, and Lord Justice Clark had set out, it's on page 905, it's recited there, at paragraphs 34, 35, 36, and 37, how the approach should be in Article 8 cases. The language of following parents who have no right to remain is not present in Lord Justice Christopher Clark's more careful statements. And we say that it is these statements that Lord Justice Elias rightly emphasizes on page 905, MS 905, not the statement of Lord Justice Lewison, which was quoted earlier at page 899 at letter E, about the child being, should the child follow. The reason why we take objection to this phrase is because we're concerned that this language has the effect of potentially distorting any analysis in Article 8 cases generally. It certainly did, I think, in this particular case, because the tribunal appeared to have approached it in that sort of way in our case. That's how the Upper Tribunal Judge Manual approached it. But we say that Lord Justice Lewison's formulation about following, can the child be expected to follow, starts from, it's wrong in these respects. Firstly, it assumes that the parent must leave. It assumes that the child is stuck with that position, with that view of the real world. That's not the child's concept of the real world. The child's concept of the real world has got nothing to do with whether the parent is expected to leave or not. And so, whilst that may be the background against which an assessment takes place of the child, when one is assessing the position of the child, one does it without bringing into play any of the characteristics relating to the parent, including the parent's immigration status. So Lord Justice Lewison's language...
So I don't understand that. I mean, surely it must be relevant to know where the parents are likely to be, because the child's best interests are obviously tied up with
Well, that's right. But what you don't do is we say you start off from this position. You ask, is it in the best interest of a child to remain in this country with the parents?
But assuming they're here, but if the parents aren't going to be here, then obviously it takes on a different colour.
If they're not here, then it may be a different colour, I agree. But that is not what the sort of case that Lord Justice Lewison is talking about. He's talking about follow the parents. And we say to use language like that, which Lord Justice Clark doesn't do, but language which appears to come repeatedly in the Secretary of State's submissions at lower levels, is potentially confusing, because what one should be focusing upon is the child in the way that is set out in ZH and in the way in which it is set out in the case of Zumbas. You ask, what is in the best interest of the child? Is it in the best interest of the child to remain here with the parents in those cases where the parents are here? And if the answer to that is, yes, it is, then consequences may arise for how you deal with the position of the parent. But the question is not asked by putting it in the way Lord Justice Lewison does, it's asked by putting it in the way Lord Justice Christopher Clark puts it, without the use of that language, and the way in which it is put in ZH and Zumbas. Because that language, that can the child be expected to follow, assumes that the assessment of the child's position is going to be materially affected by the fact that the parent must leave. But that may or may not be so. May have no status at the moment, but that doesn't necessarily mean the parent has to leave. It may be simply words that are being used, but it has the potential to confuse. And so it ought not to be used. I think I made that point to Lord Justice Elias, and he carefully did not, he focused on Lord Justice Christopher Clark's approach, which we submit is correct. But EV, of course, was not a 7-year child case, and so I'm talking here about ensuring that such dicta as falls from this court is dicta which assists, which does not cause any further potential confusion. My Lords, I think that probably covers all my submissions. Can I just make sure that I've got nothing else to deal with? My Lords, that's it.
No, thank you very much indeed. Is it Ms. Akhtar? Do you wish to follow? No. Right. Mr. Nafler.
My Lords, I'm very happy to make submissions from here. Equally,
No, the difficulty will be that they won't be picked up by the microphone. If you make submissions from there, unless you bellow, your voice will not be recorded. But Mr. Drabble is making a speedy exit, so you can come forward.
Well, sorry about that. Thank you.
It's we who should apologise to you, not you to us.
Well, my lords, my aim is to bring a fresh and, above all, a succinct perspective to bear on what is, after all, a short, albeit important, point of statutory construction. And I aim to make submissions under three headings, if I may. First, the relationship between the human dimension, if I could put it in that way, in my appeals, and the underlying purpose of the legislation. Second, just briefly, just to go through briefly, the 6 points made by Lord Justice Elias on behalf of the Court of Appeal in favour of the appellant's approach to the construction of 117 capital B6, and then to spend a little time dwelling on the respondent's approach to 117B6, and in particular her submission that the Court of Appeal's preferred approach treats the best interests of the child as determinative. So the human dimension and the underlying purpose, I appreciate, of course, that my lords will have dwelt on the facts of the case, so I will try to take those fairly shortly. But as my lords will have seen, the appellant NS has got two daughters. The eldest is VKS. She was born in Sri Lanka on the 11th January 2002. But then has lived continuously in the UK since 2004 when she was aged 2. So she was 12 at the time of the upper tribunal decision, and so she was a qualifying child, as the upper tribunal accepted. The upper tribunal judge recorded, just for my lord's note, at MS 2678-9, that VKS's head teacher had described her as in all respects a model pupil, absolutely committed to her learning and in receipt of outstanding support from her family, fully integrated into the country's education system, a popular and happy child with a wide and secure friendship group. He said, the upper tribunal judge, that he thought VKS had little grasp of Sinhala, but she could learn it. And VKS was the one who sent the judge her novella to read, the Golden Purse, which he says he read. She had a younger sister who wasn't a qualifying child, although she was also well integrated. AR's daughter was called SKR. She was born on the 2nd of September 2002 in the UK, and she was 12 at the time of the upper tribunal decision, and she was therefore a qualifying child. Again, just for my lord's notes, at MS 2677, the judge noted that SKR had passed her 11 plus. Her secondary school rated her very highly as a person with, I quote, a huge amount of potential for continuing to achieve at very high levels. And as I understand it, the judge accepted that she also was probably unable to communicate in Sinhalese and Sinhala. Her parents wouldn't be able to afford to send her to an international school, and she was fully integrated in the UK in terms of school and culture. So, as my lords would have seen, unsurprisingly, the judge concluded, and this is MS 2684, para 194, I have no difficulty in concluding that the best interests of the children require that they remain in the UK with their parents where they are settled. The upper tribunal judge didn't address in terms whether it would be reasonable to expect these qualifying children to leave the UK disregarding the conduct of their fathers, which we say is the right legal test. But he didn't identify any factor in his decision that pointed towards that conclusion. So if the upper tribunal judge had posed the test that the Court of Appeal preferred, and if it asked himself whether disregarding parental misconduct, it would be reasonable to expect the children to leave, only one conclusion would have been rationally open to him. But in a decision that illustrates the sometimes momentous consequences of what may seem rather arcane issues of statutory construction, the upper tribunal judge held that, taking into account parental misconduct, as my lords will have seen, it was reasonable to expect these children to leave the UK. And the critical factor was the judge's view, and this is MS 2682 at para 179, that the fathers had acted, as he put it, deliberately and dishonestly by pretending to complete a course of study to support an application for leave to remain, to the extent that, as the learned judge put it at MS 2685, para 199, it would be outrageous for them, that is the fathers, to be permitted to remain. So although the fathers weren't liable to deportation, so this was a section 117, capital B6 case, the upper tribunal judge clearly regarded their misconduct as falling within the very top end of the scale, if there is a scale, as far as concerns adults who are not liable to deportation. So that was the critical factor for him, and because of that critical factor, the Court of Appeal held that if paternal misconduct was relevant, the balance struck and the conclusion reached by the upper tribunal judge was one that was properly open to him. And indeed, as my lords will have seen, Lord Justice Elias went further at MS 912, para 87 is the judgment. He said this was a very careful judgment in which all relevant factors were considered. And in my view, the judge was well entitled to strike the proportionality balance as he did. So there one has it. As this particular case illustrates, if 117, capital B6, requires a tribunal to distinguish between parents who are not liable to deportation according to parental conduct and to take that conduct into account when they consider the reasonableness question, some qualifying children will remain in the UK, whereas some will have to leave depending on how their parents' conduct is viewed. And one issue for this court to consider will be whether 117 capital B6 requires this sort of conduct-based distinction to be drawn between different parents who fall within the one statutory category expressly spelled out in section 117 capital B6 of being parents not liable to deportation.
Sorry, I'm not quite sure I understand. But I mean, maybe what I'm failing to get my head around, I'm sure it's my fault, is to what extent the distinction is based on the conduct of the parents or their likelihood of remaining here. Because I think, as Mr. Gill accepted, if the issue is whether they're going to be able to stay here or not, that's a very relevant issue in thinking how reasonable it is for the children to stay here or leave. I mean, that's not punishing anyone for the conduct of the parents, it's simply recognising the reality that the parents aren't going to be here.
Yes. Certainly in my appeals, in the upper tribunal and before the Court of Appeal, that whole issue raised by the dicta in EV Philippines just didn't arise at all, and it was a complete red herring. Both the upper tribunal and the Court of Appeal, in the case of my appeals, directed themselves in accordance with the approach of Lord Justice Christopher Clark in EV Philippines. And so they looked at the best interests question, insofar as it arose, as a question that felt to be regarded by viewing the situation of the children alone, so that if it was in the best interests of the children to remain in the UK, then the parents would follow, subject to any countervailing factors. So that whole issue is a complete, it just simply doesn't arise in
clearly
these appeals
misunderstood
at all.
that. And I thought Upper Tribunal Judge Perkins did take that into account, or is that the wrong?
Not at all.
But he said, paragraph, page MS 2684, he specifically cites Lewis and EV and the problem of parents piggybacking on the children.
Sorry, I'm just finding my Lord's page. This is MS
2684, paragraph 195.
Yes, he does refer to that, but his conclusion is based ultimately on the finding that at 199, that given the parents' behaviour, it would be outrageous for them to be permitted to remain in the UK. And it was on that basis, as I understand it, that the Court of Appeal regarded the balancing exercise that he conducted as being a lawful one.
I don't understand the complaint about parents piggybacking on their children, because it's central to the statutory arrangement, isn't it?
Yes, it is. And when I look at the best interests issue briefly in that context, I'll draw attention to something that Mr. Justice Albie Sachs said about this piggybacking point in a famous judgment of his called M and the State.
Right. Well, we'll look at that tomorrow, perhaps. Very much. We'll sit again tomorrow at 10:30, and the court is, in the meantime, adjourned.